Faces and chapters from the Central European legal heritage. Welcome to the Central European Legal Insights, the podcast series introducing the professors of the Central European Academy at the University of Miskolc through insightful conversations with Judit Varga.
But here in the Central European Academy, I think that they find a lot of common spots, and that is the real substance of networking. To not only to know each other better, but to know how to react in the community and to stay different. History is also our future, because we cannot find our identity, which is important for our future life, if we don't know to read our history properly. I don't think that Serbia doesn't want to be the part of the EU, but it is definitely the EU which must be reformed, not only in attitude. It is on the appearance, but systematically, even maybe systematically in sense of European identity, to find solution for new enlargement.
Welcome to Central European Legal Insights, the podcast series of the Central European Academy at the University of Miskolc. My name is Judit Varga. I work as a senior mentor at the Academy. In each episode, we present faces and personalities of the Central European Professors Network. And throughout these friendly conversations, we would like to bring you closer to the very rich diversity of Central Europe's legal heritage, and also to explore the stories and the ideas beyond science that connect us in this region. And with this introduction, I warmly welcome Professor Dr. Vladan Petrov, constitutional law professor from the Faculty of Law of the University of Belgrade, but he is also a judge of the Serbian Constitutional Court and member of the Venice Commission. Professor, it's my pleasure to have you here.
Thank you. I will not thank a lot for the invitation. Why? Because I think that CA is, if it is not, of course, my first academic home, but it is my second academic home, so I feel like at home. So when you are at home, you don't need to be invited to be at home, I suppose.
And thank you very much for being with us in Budapest.
In a way, when I heard about the new practice of podcast you will arrange, in a way I presume that I will be one of the speakers, because I really had, and I will have a very fruitful cooperation with the CAA, and I also think that in the basis of this cooperation is really an honest friendship.
I'm very obliged to hear that. And in our episode now, we are going to touch upon all domains of your core expertise, which is constitutional law, but you are an internationally renowned professor, so we will tackle rule of law issues.
I would say regionally.
Regionally, but
this region.
For us, this is the world.
Yes.
So we are touching upon the very, very fashionable topic in this region, the constitutional identity. We are talking about rule of law and also your membership in the Venice Commission. But before all that, I would like to present you as a person, as a professor, as an individual coming from this region. And please, if you allow me to ask about your childhood, for example, when you were a child, you always wanted to be a constitutional judge? How does it start?
If you ask me, I will say honestly, I didn't plan to be a constitutional judge even a little bit before the opportunity which occurred to me, because when I was a child I had some other preferences. Of course, it is logical that I am from the law family, because my father was a judge, criminal law judge, after that attorney, and he is active in his 80s, so he's in this law practice all the time. My mother was also a judge, so maybe that was the reason. I honestly don't know. I think that it is more because I liked a lot history. History was my maybe my first love. And also I liked all social sciences, and also I liked poetry, and I liked music. I like also today, but in this formative period of time, those are several activities which were in a way interlinked. And in the center, in one period of time, but very important period, when I was between 12 years old and 18, it was football. I was a goalkeeper, and my philosophy of life was always to defend something or someone or some ideas, some principles, and that philosophy of goalkeeper who defend his goal, and that was something which was really amazing to me.
Wow.
And maybe there is, I suppose, some connection with defending your team at the football pitch, and defending your state, your constitutional order. As
I like this symbolism, and remaining with this symbolism of football. If you are the goalkeeper now, who are the strikers who are shooting your goal to defend your constitution?
I never felt that strikers are my opponents, and maybe because it was one of the reasons why I wasn't quite successful in this goalkeeping mission, because sometimes in a real world you have to know that you have some enemies. It is normal, but in our world, in world of law culture, and also in the world of law institutions, I think and I hope that it is also the world of political institution, or it should be. All the strikers are usually not enemies. We have always be prepared for conversation, for dialogue.
Like in a fair play.
Yes, so those strikers were not the enemies, but they made some challenges for me to, in a way, to mix in my future life the discipline, which is usually related to sport, and some kind of I would say the sense of community, because I think that you said today that, or some of our colleagues, I don't know, that you cannot succeed. You can succeed alone, but the real success is success of your community, and this is about it. We are CEA, the community or the network of professors, students, and that is definitely the future. So I think that except my personal professional characteristics, I have some maybe inherited or also socially defined characteristics which are very good for working in some communities which are based on some, if I could say, some rather firm principles and values, because a good lawyer have to be very persistent in defending the principles of his community, of the law culture community, and very, in a way, flexible, I should not say vague, in finding the most appropriate way in peculiar situations, in specific situations, to operate these principles. We will talk about it. Probably it is the philosophy of life, and especially legal and political life, how to implement some universal principles and values, and not to lose them in that process of trying to operate.
Yeah, very interesting issue, and we have to tackle it later. Just a question about your personal career, if I may. So, was it crystal clear already at law school that your professional future lies in research, academia, and constitutional law, or there was a certain moment in time? Was there a game-changing momentum?
You know, when I decided to go to law faculty of Belgrade, it is the biggest and, of course, most important faculty in Serbia. I failed in my sport activities, and so I realized that I lost some chances to be a successful goalkeeper. So I went to law faculty with, I can say, with the goal to become a judge. Not any type of lawyer, because we all know that with law faculty you can do it almost everything after you graduate. And what was one of the moments which were in a way lightening for my future academic career. Maybe it was one lecture that I gave as a student when I was preparing and talking about the principle of separation of powers. And the assistant at the constitutional law at that time was really amazed. She thought that my presentation was so educative, so highly academic, that I was really surprised. I didn't understand it well. I wasn't aware of it. And the second event, which was probably the most important, is I just decided to try to become the assistant at law faculty, and I entered the law faculty almost by accident. The professor, he was one of the most important professor of constitutional law in the second half of our century and the beginning of this 21st century, and he was at that time vice president of our government, of the Serbian government, also with some other important political activities. He accepted me as his child, and he taught me how to use some of my abilities in relation to youngers, in relation to students, because he thought that I was, and maybe I am now also, I don't know. It is not on me to tell that I was very, in a way, not physically, but intellectually and in appearance attractive for students. He was joking that I spoke very loudly. So in the big amphitheaters,
and that's useful.
Yes, it is useful, and that I was, when I was younger, I cannot say that it is today more different, but I was in a way full of some kind of positive energy. I was always laughing, and maybe because of that, he thought that I would be a really good professor one day. So I cannot say that I was born with the idea to be the law professor and the judge of Constitutional Court, and I can say that I enjoy in this job more today than it was at the beginning. Maybe it is also connected with some deficiency of time, of space to do some ordinary professor jobs, like reading the books, writing the articles, because in previous period of time I had so many public activities, public functions, that in a way they a little bit put me aside from this central focal academic point of my life, and that is definitely my professor work.
Actually, this was supposed to be my question: how your present position do interact with your activity as a professor of constitutional law, because it keeps you on a pragmatic or practical level in your research, being also active constitutional judge, member of the Venice Commission. How does these positions interact? How do these positions interact with your professors?
I'm trying,
capacity?
but I cannot say that I'm trying. I'm simply the person who cannot make some walls between theory and practice, between my students and lectures on the one hand, and my judicial practice and public activities on the other. In a way, I always mix it. But when I am in the amphitheater, when I give some lectures, I try to put the practice in the adequate place, not to say to my students that everything is bad in the practice, not to be so critical about the practice, but to inform them that the theory or the norm, the ideal, that idealistic sphere is interlinked with practice, and that it is in a way dialectical interaction between two of them. And I think that in a way I witness that with my appearance, with my activities, which are usually interlinked. They can see on the exams, or even sometimes in the period of lectures, that I work almost at the same time several different jobs. It was not my plan when I was young. I must say that I was even critical for those professors who usually improvise something. But today I can also say that I have the power of improvising, but because the fundamentals are very strong, and because it is not maybe the typical for an average professor, but I think that it is the characteristic of very successful professor. It doesn't mean that I am a very successful professor, but I am really a person who works a lot. Work is maybe work, love and work, and usually, unfortunately, sometimes is love for work. It is not always love for
Your
which is
wife is
directed to
listening.
another. Yes, yes, but it is it is difficult to make differences between those things because if you have to be successful, we have to be realistic, and you have to be yourself. And then if you have to be yourself, then you are with all other people's in a way the same. You are you.
Yes.
You are you. And of course, you are. It is not only the personal characteristic. You have to be. I will talk about it. You have to be a very disciplined. Because sometimes you can go to the heaven and think that you are the professor from the heaven. It is not good. You have to understand your students, young people, young researchers, and to be happy to give them even more than you can in some specific situation.
I think you have very lucky students because they have a professor like you who can actually put together practice with theory and also evidence it with his own
in Serbia,
life.
I don't know if it is also in Hungary. We are in a way, in our mentality, there is a lot of similar characteristics, but of course, a lot of differences. But in Serbia, we have a habitude to criticize a lot the public officials, those who work in public a lot, and I think that it is a healthy habitude if it doesn't transform to the extreme. When you critique,
it's constructive critique.
Because you think that you know better, and that is the link between theory and practice, between the institutions in norm and the institution in practice. When I entered the Constitutional Court, at that moment of time, I was one of the biggest criticizers of the work of the Constitutional Court. But one of, I am really honest, one of the elements of that criticism, which was of course negative, was my I don't have the practical knowledge about the functioning the Constitutional Court inside, and that is one of the topic of our conversation. It is very important for our institution, for the Central European Academy, to public to our insights, our activities which are very familiar to us, but maybe they are not enough familiar to public, not only to professional public. In my opinion, it is also very important to enter in a way into minds of the ordinary people.
Yes.
Because we will talk about it, because the role of law, it is not a phrase, it is the great truth. It is not in the books.
Yeah.
It is, but if you want to make some comparisons between the books and the practice, if you want to find some real relations between those two spheres, you have to know the practice and you have to live the practice.
Exactly.
I know that you understand me well.
I understand it fully.
Because we usually hear that theory and practice are interrelated only in the books.
Professor Petrov, let's dive into the professional content of our conversation, which actually one of the most important domain also of the activities of Central European Academy, the constitutional identity. And now we would like to focus on Serbia. the Serbian constitutional history and also the Serbian constitutional identity. When I was preparing for this podcast, I actually scanned through and read through most of your contributions in the past when you participated in the activities of the academy, and I found a quotation from you which I would like to read, and also to immerse with us into the history of the Serbian constitutional development, of course, naming landmark historical momentums. But the quotation reads as follows: European identity is legally rooted in the core of the modern Serbian constitutionality, even though Serbia is not yet an EU member state. And I would like to ask you to reflect on the Serbian constitutional development throughout the 19th and 20th century. What features of those constitutions do you consider were the most formative for today's constitutional identity? And also, how do you balance the influence of historical constitutions with the need to meet the contemporary European and international standards, which you are aware of very well, being actually member of the Venice Commission?
Yes, this statement of mine was one of those which I regularly mention, because I am one of those who thinks that there is a lot of differences and substantive differences between the Europe, not in an abstract concept, but as a historically and culturally rooted realistic concept, and the EU. And I am always prepared to defend my state and some of the appearances of some of the practice of functioning of constitutional institutions today towards those strikers who say that Serbia is not European or not enough European legal state. Why I say that? One of the reasons is because of the notion or concept of national constitutional identity. I am very aware that Serbia is on the path to define it, that it should have defined it maybe faster or maybe even in the period of the 90s of the 20th century. I am aware that we are a little bit late, but I know that we have some good historical facts, monuments, milestones, as I said, which can be very useful for creation of that national constitution and also national, in a wider sense, political and cultural identity. And how do I approach to the history? I approach to the history as not only as through constitutional acts which are milestones, but I approach the history as a process. And I think that it is one of my common statements that this process is not finished in the past. History is also our future, because we cannot find our identity, which is important for our future life, if we don't know to read our history properly. It is not through some mythological concepts or ideas, but through some normative facts and some socio-political importance of some acts and processes. And for example, when I was talking about the milestones, I mean the constitutional acts which are important even today. I was paying attention on two criteria. The first is the normative quality of those constitutional acts, which were in a way not deeply related to the socio-political background. In a way, we are teaching our students that it is very important for the constitution to be vivid, to be realistic, to be much more in accordance with the socio-political situation. But good constitution is not only that kind of constitution. It is also a constitution which can be a project for the future. So in all those constitutions that I mentioned, and I mentioned 4 constitutions in very
which have this normative quality.
Yes, in very rich constitutional history of Serbia, predominantly predominantly in the period when Serbia was a sovereign state or at least autonomous, not the period when we were the part of Yugoslav state, the first Yugoslav state and the second, especially the second because it was a socialist type of constitutionalism, but with some very unique elements in relation to our self-government, constitutional, etc. But those 4 constitutional acts have really some normative qualities. This is the first criteria, and the second criteria is something which is in a way not possible to describe or to give some definition. It is something in that constitution, something in it, something which is related to their unique characteristic or habitus, something of their authenticity. Because the identity in larger sense, and also the constitutional identity is, in my opinion, related to the habitus of a person, of a society, of a political community, of a constitution. So it is those 4 constitutional acts. The first was, I will list them very shortly. The Sretenje Constitution from 1835. Serbia was not a sovereign state at that period of time. It was autonomous province of the Ottoman Empire. But what was really important in that constitution, Sretenje in Serbian language is in English some kind of, it is also an orthodox celebration, but in a simple language. It is, and fundamentally, not only simply, it is gathering. It is gathering. It is a meeting, which is not only physical meeting. Sretenje means that the heaven and earth is meeting, that some, in a way, universal principle and some concrete circumstances are meeting. And because of that, Sretenje had a symbolistic character in our constitutional history. Unfortunately, it was in the terms of one author from the beginning of the 20th century, who was a really great constitutional lawyer and also good in some other law branches, but he was also in one period of time the president of the Serbian government at the beginning of the First World War, Milovan Milovanovic. He said that this constitution was stillborn, and in a way, because he lasted very quickly, he was effective only several weeks.
So this is why it is stillborn.
Yes.
Stillborn.
Yes, stillborn because of that. Because this constitution had its symbolic function to constitute the aspiration of Serbia to become free and sovereign country, and to organize itself on two principles which are common today, but which were not common in that period of the development of constitutionalism. And the first principle is the principle of division or separation of powers, and the second is a very, very respectful catalog list of human rights, which was a little bit rare for the constitution in that period of time. And I must stress that this constitution was probably the first Balkan constitution. So the symbolic function of this constitution is very important for formatting, for creation, the national constitutional identity. The second is...
sorry, Professor. So it was in 1835. This was the Strategnic Constitution.
Yes.
And it was the stillborn constitution, so more symbolic than operative,
because
it never had the chance to function as a living...
the great forces in that period didn't want Serbia to have it. So maybe this is one of also the important messages for Serbia, constitutional identity, to formulate something, the concept, which will not be antagonistic to real European values.
Thank you.
The second constitution, really briefly, was important because it firstly introduced the real National Assembly, and it was in 1869. It was called the Regents' Constitution, and I will not go further to explain its content. But the third one was very important. It was called Radical Constitution in 1888 because of at least two important characteristics. The first one was that the kingdom, Serbia became the kingdom, sovereign kingdom in 1882. So it was actually the first formally and materially complete constitution, because those previous constitutions were not the constitutions of the formerly sovereign state. It was they were the constitutions of the autonomous province of Ottoman Empire, and this constitution was important also for the second characteristic of its normative quality. It was really well written, with a lot of new solutions in comparison with European constitutionalism of that time, which was which was liberal democratic oriented. For example, the constitution proclaimed the parliamentarism as a system of government which was quite rare in the second half of the 19th century in Europe. I just want to remind you that in that period of time, only Brittany and maybe France had some kind of, in a way, developed parliamentarism. All those countries around Serbia was far away from parliamentarism. Of course, the Serbia in practice was also far away from parliamentarism, but this highly idealistic attention of those constitutional writers was really something very important, and also some other solutions from this constitution are really, I can say that they can be put in our modern constitution and to be really effective today. But of course, this constitution was also in a way still born. He was changed with the another constitution which were more authoritative, authoritarian, not authoritative, authoritarian more. And the fourth constitution is not from the 19th century. The fourth constitution is much younger, if I can say, for a constitution which was brought in 1990. Why it is the four milestone? Because firstly, it was in a way the first constitution after this one from 1888, which was brought in 1903. But this constitution from 1990 was a real legal follower. It was a real example of continuity of classic constitution. It was in a way this link with those good days of constitutionalism of Serbia in 19th century, good in normative way, not in those relation with real life. But unfortunately, it was that constitution of 1990 fortunately had a good potential, because I can say it is maybe not so well known. If I can conclude with this first topic, it is very important to deal with those four constitutional milestones not as a finished, stillborn, dead, constitutive and in a way static act, not in a static way, but in a dynamic way, to feel that it is, to realize that it is a process. We have to analyze those constitutional processes which were maybe far from our modern point of view, but to find some good solutions and to say that we were, in constitutional terms, really the state or the country or the people of the European constitutionalism. That is very important. Our feelings, usually very positively oriented or almost predominantly positively oriented towards east, towards the other corners of the world, are in a way, I think, positive. But in constitutional terms, in finding the right balance between our national peculiarities and some good universal constitutional heritage, I think that we should be very open to European constitutionalism, because this constitutionalism, especially the French constitution, not only the French, there are some German influences, but not as French influences, those influences are in the main, in the roots of our constitutional heritage.
And we came back to the quotation where we started this session, actually, that it is well rooted in the European constitutional heritage. Actually, I would love to continue with the history of the Constitution. However, time is running so fast, and I would suggest to move to the European integration procedure, because all what was said before is having a living impact on the integration process, and also the the not collision, but the meeting of the European standards, requirements, and the constitutional identity. We also have had our pathway in Hungary. We still have this battle with rule of law interpretations coming from Brussels. But now I would like to hear from you your views about the integration process of Serbia. In one of your presentations, I also made a note where you said maybe it's not a legal process anymore. However, still there are a lot of requirements, judicial reform. So I would really like to hear your views, your authentic views on that.
You don't have to be clever a lot to say that it is not a legal process, that it is predominantly political process. But to joke a little bit, when you ask me to go further, to go to the another topic related to European integration process, my first association in mind was that is history also, but it's not.
Since when is it going?
No, it's not a history. I really think that Serbia, maybe it is a rather political statement, but how to deal with the process of EU integration without having, I will say, principal political attitude. And in my opinion, this is also the future of Serbia. In my opinion, it is something which is at this time it is not questionable. But the politics of conditionality, not constitutionality, conditionality of the EU towards Serbia. If you want to be only objective, or maybe a little bit EU-oriented, but not radically, you have to admit that the politics of conditionality, the conditionality politics of the EU towards Serbia was and is of the highest expectations. I don't think that I say that because I come from Serbia, but the political conditions in the process of accessing the EU are really predominant in relation to those legal conditions which are common, which are standards, in which we are not so good. I must admit, I think as a legal expert that we could do more in that legal aspect of that process. Mm-hmm. I have a lot of, I'm full of criticism, I must admit, in relation to the dynamics of the operationalization of the legal state. I prefer that term instead of rule of law. I think that we are not always sincere in our legal reforms. One example is really fresh. You know a lot about it because you were the Minister of Justice at that time. But we had the constitutional and legal reform of justice, of judiciary,
yes.
Not the whole justice system, not the constitutional justice, but judiciary 3 years ago. And that process is normatively just if I can finish, but 3 goes after the constitutional referendum, which was also well accessed in the EU, well accessed and very excellently accessed by the Venice Commission, and which was also I thought, which was also the sincere duty of our political part of state or of our government. Now we have some totally different approaches towards that constitutional reform, and you can say among the people, especially among the politically involved people and even in the ruling party, that those reforms are just something which was forced by the European Union, etc. And it is not a good approach. It is something which is also inherited from that period we were talking about. We are sometimes very full of contrast and some contradictions in our attitude towards some important constitutional and other reforms. And because of that, not only because of that, we are very late in effectuating. We are not enough effective in that aspects of the legal process of the EU integration. But politically, we have to be honest. At the end of the story, if it will be the end, I mean the end. If we the end say that the end is the accession of the EU, I cannot say that we can do it without leaving Kosovo and Metohija without our constitutional protection. I deliberately used that syntagma or phrase, the Serbian constitutional protection, because I don't mean only about territory. I mean about people who live there. Yes. Because they live in more and more difficult circumstances, and unfortunately the EU as a moderator in the previous years, and it is also now the case, it is not enough neutral in its attitude, and it is also not enough effective in a way forcing, but diplomatically forcing, two sides. I accept that there are two sides. I cannot say that those sides are completely equally, I mean Serbia and Kosovo, but they are definitely two sides. There are two entities, but according to our constitution, the second entity, so-called Kosovo, is not totally independent state, and I think that is the way of bringing together, bringing some positive approach to this process, is to find a kind of solution, not to leave Kosovo and Serbian people without constitutional rights protection, and also not only constitutional rights protection, but protection of our identity, our churches, monasteries, spiritual milestones at that territory, which is, I told you when we prepared for this podcast that in the identical meaning sense of identity sense of Kosovo is not just territory, and it is not exclusively the territory. So if we want to be in political process more proactive, we not we as Serbia, but also the EU have to be more neutral and more proactive in this in the initialization of dialogue, not only the result of so-called dialogue, but in dialogue which will maybe last for a very long time. And of course, not only the Kosovo is the problem, political problem, as all of you know. Unfortunately, a good, I can say, a bad destiny follows Serbia on its European path, because this war in Ukraine, or Russian-Ukraine war, aggression, because we qualified that as aggression as our official statement, it was not only a disaster for whole Europe and for whole the world, but specifically it was a disaster for Serbia and its European integration, because it even complicated the state of affairs. And another very difficult to achieve political request was introduced to introduce sanctions to the Russian Federation, and I think Serbia, of course, and I think that we know the history of EU integration process of other members of states, the totally or full alignment to the foreign policy and security policy of the EU was not the demand before the Ukraine war. And now it is the absolute request for Serbia. Also, as Serbia is constitutionally and internationally inherited the former Yugoslavia, Serbia is one of the constitutional and international guarantee of the Dayton Constitution, Dayton peace agreement, and the situation in Bosnia and Herzegovina, especially related to Republic of Srpska, and the continuous intentions of political centers of powers in Sarajevo to centralize Bosnia and Herzegovina, and the attitudes of the European Union towards the role of Serbia in that process is also very difficult for Serbia. So I will finish, there are not only Kosovo, there are a lot of political preconditions and conditions, and which make this European path, EU path of Serbia very weak, very difficult. And if I can conclude with the sentence I think that I told you before, I don't think that Serbia doesn't want to be the part of the EU, but it is definitely the EU which must be reformed, not only in attitude, it is only appearance, but systematically, even maybe systematically in sense of European identity, to find solution for new enlargement. the geopolitical situation in whole the world is definitely not the same, and the EU is not the same. So I think that we have to find some more realistic approaches if we want some positive steps. I have to say that we didn't open even the formal clusters until the last cluster was the cluster 4, after the constitutional reform of judiciary, and that was at the end of 2021. So 4 years elapsed in practically nothing. So I cannot be so optimistic, but I am optimistic as a person. So maybe my personal optimistic way is something which I have to transfer to others. And I don't want to mention current politics and politicians, but I think that this current approach of Serbia in relation to foreign policy, and that is a policy towards all four sides of the world, is the politics of future. Does it mean that it is not the politics which will brings us to EU? I cannot say exactly is this so, but we'll see.
Well, thank you, Professor. Actually, I would really love to spend the whole day with all these discovery in the internal context, because really sensitive, really difficult, but I am certain that we have to talk about them at a certain forum or momentum. But now I would like to ask you to put on your hat as a member of the Venice Commission from Serbia. And here I also would like to use one of your own sentences in one chapter that you stated, that although the Venice Commission plays a significant role in the standardization of the rule of law in Europe, impacting the domestic regulation, it has not always successfully and consistently managed to stay outside the political forum that may pose challenges to maintaining its professional relevance, referentiality, and operability in the future. What is your own experience about this challenge?
Very briefly, because I talk too much about history and about the EU integration process, but you know, the Venice Commission is definitely the organization, as you know, 35 years old, because it is founded in 1990. At that period of time, the Venice Commission was part of this EU and Europe enthusiastic wave, and I think that its role in helping constitutional transformation of the former real socialist countries was really positive, not only in general, even in almost every details, because sometimes it is necessary to do first normative steps and then to transform the legal consciousness. It is good to in a way to make both immediately or spontaneously, but it is very difficult. And nowadays I see from the inside that nobody and no one, and there is no organization in the world, even the United Nations are not good example at this period of time. And logically, even the Venice Commission cannot be outside the politics, outside the influence of politics. Who can be outside the influence of politics? But what is one of the strategically good points of reference for the Venice Commission is, in my opinion, I'm not talking about any specific cases, but in general, that Venice Commission really succeeded to play some kind of moderatory or intermediary role between the law and politics, between some standards and principles of the European constitutional heritage, which is not just a concept, abstract concept. We all know that it does exist, but it is a dynamic concept, and I think that maybe the new task for Venice Commission is to develop that European constitutional heritage as a more dynamic concept related to the national identities of every state member of the Council of Europe, and not only of the Council of Europe. And the example of Serbia in doing constitutional reform, constitutional amendment of judiciary is quite representative, because I know, because I don't know why it was like that. Maybe it is my destiny. I was one of the maybe the unique example who was at the same time the member of the Venice Commission and the holder of the constitutional expert part of the story
of the judicial reform.
Yes, and they let it because I will tell you that for the first time publicly, because they when I say the administrative leadership of the Venice Commission, which is always very important and maybe the most important, they thought that I can be that factor of making real dialogue between two sides.
It's a huge level of trust.
Yes, the level of trust was very high at that moment of time. And of course, it was not because of me that I think that it was a representative example of good cooperation, but because of that dialogue, which was, it was very politically oriented, because all know that at that period we really wanted to make some progress towards EU, but on the other hand, they were very positively oriented towards some suggestions which were concerned some national characteristics of functioning of our institutions. For example, they were not decisive about the role of the president of the highest court, of the Supreme Court, as a member of the High Judiciary Council. Mm-hmm. Or, for example, they were more decisive and they were more imperatively oriented towards the High Prosecutorial Council and prosecutor, the highest prosecutor, our highest prosecutor, Supreme Prosecutor. They wanted out of this council, and nowadays we see that they were maybe right. Mm-hmm. That they were maybe right. It was not a politically oriented suggestion or recommendation. Maybe we thought that it was, mm-hmm. but it was, I think, it would be better that we accepted that, because we constituted the council with the Supreme Prosecutor, who is in a way responsible only to the council in which she is the main actor. So what I want to say, the dialogue was good, the dialogue was constructive, and the attention of the Venice Commission, of course, because we had some luck with the rapporteurs who were very experienced and I must say very positively oriented towards Serbia at that moment, Serbian institutions. I can say that Venice Commission did a good work. Unfortunately, I cannot say that it was the case in all other situations.
Okay.
So, but who is perfect? The Venice Commission is based, and I am finished with that, is based on an ideal that there can be internationally recognized body of legal experts who are almost totally independent. And I think that it is a big lie. But a big lie, not totally, but the concept should be a little bit more realistic. There should be an internationally recognized legal expert body which is capable of make a balance between the requests of legality and rule of law and national peculiarities on the one hand, and politics, European national politics on the other hand. So making the balance is one of the most important things in life. So you cannot be absolutely independent, but the success then you can fulfill in your life, and also the Venice Commission in its life, is to be the more autonomous it is possible in the legal sphere.
Actually, that sounds like a message to younger generations of researchers to be
Definitely,
realistic.
if they want to be the person of integrity, they have to really work hard and disciplined, to be focused more than average person, to be focused more than average person, and to be to find a balance between ideals and reality. And in relation to this topic, that means to be very autonomous even sometimes in relation to friends, which can be emotionally involved, but we cannot be, you cannot be, younger cannot be totally independent from everything, from their history, from their historically and mentally rooted prejudices. Then they cannot be independent from all kinds of factors which are meant or maybe accidentally or deliberately meant to influence them, from family, from their friends, from some students who are their students, who will be their students, because when you work in functioning of legal institution, then you have to be prepared to, in a way, to defend. At the beginning was to defend themselves from all those influences in these negative aspects. What is only the only key? To rely on their masterpieces, to rely on their real knowledge, and to be flexible towards social and other relations and situations. So not to be enough rigid, to be unfortunately it happens to be broken emotionally, physically, psychologically. That is the very success, because if you want a real success, you have to last. It is not only to be good at studies and postgraduate studies, but to last long, and of course, if it is possible, to get a position that your word counts.
And would you recommend for your students or for any Serbian young fellow to come to the Central European Academy? And if yes, why? What can they find here in your position?
Is it necessary to say something about it? I think that it is really a very healthy academic place, very open. I can say even for those who are now in Budapest at the fourth conference, I know them. I think especially those who come from Serbia, they are very different. They are very different in their way of thinking, even ideologically. But here in the Central European Academy, I think that they find a lot of common spots, and that is the real substance of networking. To not only to know each other better, but to know how to react in the community and to stay different. What should be their common characteristic? Their common characteristic, in my opinion, very honest opinion, is to be proud of her state, of her nation, and to be very open to interact with other states and nations.
This sounds like a perfect
to love their motherhood and fatherhood, and to love their identity, but to be prepared to act in creating even the more important identity of which are not nationally, which is international, supranational. We are talking also about it when we talked about the Venice Commission and the rule of law, etc.
Thank you very much, Professor Vladan Petrov. It was my pleasure to have this contentful discussion with you. I hope that also our audience, they got closer to Serbian constitutional identity. I ask you to follow us in the next episodes as well, and I really appreciate your time.
We hope you enjoyed this episode of Central European Legal Insights. Don't forget to follow us on our social media channels for updates. To discover more conversations from the series, be sure to explore our other episodes. Thank you for listening.